Good morning. Everybody can hear me? Okay, a few comments. No one's here to give me a great introduction and tell you how wonderful I am, but I know a lot of you, and as it was just said, my name's Anthony Gair. I'm with the firm of Gair, yada, yada, yada. And we've been doing this program now since, I think, 2006 or 2007. I've been doing construction litigation for close to 35 years, and during that time, as those of you who are from my generation, have seen the labor law, construction law, swing like a pendulum. That's how I like to say, talk about it. Let me ask you something, because you all got this book they handed out. I want to be clear, this is not the submissions that people took a lot of time in doing. Did all of you get the email from the State Bar with the submissions? Yes? Okay, good. There's two submissions. I'm going to be speaking, obviously, on the law. There's two submissions on the law. There's Brian Schiff's terrific one, which covers every aspect of the labor law. There's one that I put together with my partners, Chris Sally and Howard Hirschenhorn, that focuses on Section 240. It's pretty long, it's about 135, 140 pages. And between the two of them, you're going to have most of the cases in them. Now, a couple of things. How many of you here do defendants work? Yeah, I looked at it. A lot of people here, a lot of plaintiffs reps are here. I saw a lot of people, some people in the work are here, and the rest obviously do plaintiffs. And I take it that everybody does a lot of construction accident work, right? Yeah. Okay. Now, there is a great source to keep yourselves up to date on cases on a weekly basis, and that's on LinkedIn. Scott Generelli, who some of you may know, has a LinkedIn group, and it's called New York Construction Accident Lawyers Group. And I don't know how he finds the time, but each week Scott posts every appellate division case involving the labor law that came down during the week. And I think he posts them on Tuesdays and Thursdays. I look at them on Fridays or Saturdays. But it's an invaluable resource. So if you're on LinkedIn, just join that group, and it's really something that'll keep you right on top of it. Also, those of you who use, and I know all of you use either Westlaw or Lexis, you can do the alerts. I have alerts for anything to do with Section 240 that I receive on a weekly basis, so I can look at the cases that came down. They're a little sometimes dated, and I don't have the time, as I'm sure many of you don't, to go to the four divisions sites and look at the cases. Scott's doing that for us on this group, so it's a great resource. All right. Now, we can all agree on one thing, those of us who have been doing this even for 10 years, but certainly for those who have been doing it for longer than that the labor law is like a pendulum. It swings back and forth. At one point in time, it favors defendants. At another point in time, it favors plaintiffs. I never find it to be that neutral. It's very judge-oriented. It's very akin, I always compare it to the Supreme Court cases in the area of criminal procedure. And you had the Warren Court, and all those decisions have been modified or reversed or just ignored. In the area of construction law in New York, courts don't seem to follow precedent. I'll give you an example. Back in 1978, we had a case, and many of you may know it, Haimes versus New York Telephone, which was decided by the then Chief Justice Jack Fuchsberg, who had been a very famous plaintiff's trial lawyer, and it was a worker who had put up a ladder and didn't know whether he fastened the safety clip, or he didn't fasten the safety clips. In fact, it was, and summary judgment 240, he wins. Then, many years later, in 2003, we have Blake versus Neighborhood Housing Services, and which introduced, well, there was no whining there, but Blake really introduced the sole proximate cause defense as something that defendants could use to really either get cases dismissed or at least to raise questions of fact. Blake was the exact same case as Haimes. It was the same thing, a ladder, and it was the plaintiff didn't fasten his clips. That was a case that went to trial, so the Court of Appeals wasn't reviewing really the fact. It was just questions of law. And he lost on the sole proximate cause defense. And in that Court of Appeals decision, they didn't even mention Haimes. So is Haimes good law? Obviously not. But I guess it was tacitly overruled. So that's what I mean by that. So basically this. If you look from the late 70s through the early 90s, there's no question about it. The law in the area of construction accidents clearly favored plaintiffs, no doubt. And it began in the early 2000s to swing in favor of the defendants. And you had really 4 major Court of Appeals cases that achieved that result. You had Blake in 2003. You had Cahill, the recalcitrant worker case versus Tri-Bridge Bridge and Tunnel Authority in 2004, which also didn't mention the old cases, the Stolt, Hagens, Zimmer, Smith, and Jasper Biscuit, which were all decided around 1996. You ignored them, and there was, in Cahill, there was a far removed instruction to put on your safety harness. So that was decided in 2004. Then you had Montgomery in 2005, which you'll recall the elevator's mechanics helper didn't have a ladder, so he got up into the elevator room, and they used a bucket, but he couldn't get down, so he jumped and injured himself. And although there was no proof that ladders were available, and it's admitted, they tossed him because he should have used. His logical response should have been to go and get ladders, or I don't know where that came from. But, and listen, I'm not here as a plaintiff or defendant's attorney. I'm here telling you what the law was. I'm here as an advocate. And then you had Robinson, which was also a sole proximate cause case where the plaintiff got tossed. So, as claims representatives, as lawyers, we would like to know exactly what the law is. And unfortunately, we often don't. However, we sort of do now, because in 2009, the pendulum swung really, and we all know this, the defendants know it for sure, felt really in favor of plaintiffs, dramatically so. I mean, a major, major change. And I'll talk about that in a minute. I just want to, all of you know when the labor law was first enacted? It was first enacted actually in 1895. And then it was amended in 1925 and 47 and 62 and somewhat thereafter. But it was, and I'm talking about Section 240. That's what I'm speaking on. And Section 240 was known as what? The scaffold law. And it was known as the scaffold law because what happened is, if you read Blake, it really has a good history. I'm not so happy with the decision in Blake, but it has a good history of the evolution of the labor law. And you know, all these buildings were started going up, and these people were at great heights on scaffolds, which were totally unsafe. There was no regulations at all. There was all these injuries. So in the late 1800s, they enacted the law, and then in 1921 it got more firm, and 47 is pretty much similar to what we have today with some variations. But it was a scaffold law. It was people working at major heights who were in danger of falling. Well, we all know that today it's something else entirely, isn't it? And so, when I say the pendulum began to swing, it swung. Let me start, because time goes very quickly here. At law line, they give me an hour and a half, and I never finished. So, but let me talk really quickly about elevation-related differentials and falling objects, falling workers, and I'm going to lump them all together. Now, everybody knows, I'm sure, Runner versus New York Stock Exchange decided in 2009. Everybody knows the facts, right? So I don't have to go through them, or does anyone need to know the facts really quickly? Quickly, okay. Very quickly. The plaintiff and his co-workers have to decide how they're going to get an 800-pound reel of wire down 4 steps of stairs, okay? They decide, the plaintiff and his cohorts, to become human counterweights. So they hook a rope around this 800-pound reel of wire. They put a brace in between a door like a jam, something like you can do pull-ups on, and it's really stuck in there. They take the rope and double wrap it around, and they stand back. The plaintiff is one of them, standing back. And so just think of it. You know, I usually use Howard Hirschhorn. You know Howard? He makes a good 800-pound video. Anyway, so they listen to this. So they tie it around, right? They put the rope up there, and someone pushes it down the stairs. Now listen, these are strong guys, but there's 800 pounds. So what happens? They pull, and the plaintiff's hands are smashed into the bar. He never falls. In an opinion written by Judge Littman, who he held that 240 applied, and the plaintiff was entitled to summary judgment. And the most important language used, Runner has been cited, and is a 2009 case, as of 2 days ago, 230 times. That's a lot of times for a 2009 case. Because it's a very significant case, and you see it all the time. And defendants and plaintiffs, we all have to be aware of it. And some people misread Runner to say all you have to do is look to see if it's a 240 case is whether the force of gravity was involved. Untrue, not so. You saw, they're in my outline, they're in Brian's outline. You see cases right after Runner misinterpreting it and holding that all you needed was a heavy object, the force of gravity, and you had a 240 case. No. The most important statement in Runner is this, and I'm quoting, the single decisive question is whether plaintiff's injuries were the direct consequence of a failure to provide adequate protection against the risk arising from an elevated related differential. Okay? So, don't think as plaintiffs, and know as defendants, that a plaintiff still has to show an elevated related differential. Only Not so much. The court, in the context of the facts of this case, because the plaintiff didn't fall, came up with this other statement that the relevant inquiry is whether the harm flows directly from the application of the force of gravity to the object. Well, that was because they had to, in writing this opinion, where you didn't have to have the plaintiff fall, you had an elevation-related differential, which was the difference between the elevation of the reel and the floor, but the plaintiff was hurt because of that elevation differential, because of the force of gravity being pulled into the brace. Okay, that language comes right out of Ross versus Curtis Farmer. Anyway, so now, in order to have a Q40 elevation-related case as a plaintiff, you have to show an elevation-related differential, but not, as I said, much, because you also have to have, you can have the force of gravity, you have the force of gravity language, which implicates the weight of the object and the force capable of that object being generated even over a short distance, which is why you're seeing all of these cases, these numerous decisions, which I speak to most of the people I deal with in the construction cases are defendants' lawyers, because that's who I see. I don't hang out with plaintiffs' lawyers. They're not going to get any money. And also, those are my friends, because we see each other all the time. And so that's who I know. And they're tearing their hair out over these cases, as I'm sure a lot of you are. But there's hope for you guys, because I think the pendulum's about to swing. I'm going to tell you about that in a minute. But as a result, we've seen all of these numerous decisions where Section 240 has been held to be implicated. In fact, plaintiffs have been granted summary judgment where the fall of the plaintiff or the object was a foot or 2 feet. Okay? Now, I told you, I'm not here as a plaintiff's lawyer or as a defendant's lawyer, but just as someone who knows about the law. And I told you at the beginning for a reason. This law was called the scaffold law. And it was really used for people who are way up on the ground, and now it's something quite different. And philosophically, I think workers should be protected. Maybe we should have a section 240 subdivision 8, heavy objects. Something like that. Anyway, so here's what a plaintiff. Here's the language of all of these cases where you have this 1, 2, 3 foot differential, and it's the same in every case almost. And I made some up. I didn't make it up. I generalized it from the cases, but despite the fact that the scaffold, beam, object, plaintiff, etc. Forget the plaintiff. Despite the fact that the scaffold, beam, object, etc. either at the same level as plaintiff or fell a short distance, given the weight of the device or the combined weight of the device and the load it was carrying, and the force it was able to generate, these short distances cannot be viewed as de minimis. That's what these cases all say. And they're all in the Gair et al. Outline, and of course in Brian's great outline, which is certainly, I take Brian's every year and download it so I can have it. And on even any of these outlines, you can do Control F and do your searches for anything you want. For those of you who don't use computers, Control F search. Okay. Now, there's another important case other than Runner, which I'm sure you all know, which also changed the playing field for plaintiffs, and that is Walensky versus 334 East 92nd Street Housing Development Corp., decided by the Court of Appeals in October of 2011, October 25th. Does everybody, you want the brief facts of Walensky? Everybody know Walensky? No. Okay. Walensky also is a case, 2011, cited 91 times as of a couple of days ago. Very, very quickly. In Walensky, they're doing a demolition job. They're at the point where there's two 10-foot beams left standing, and they're getting walls knocking down and everything. But these beams are standing. They're from the floor, rising up 10 feet. So the plaintiff happens to be 5'6", and some debris falls, hits the beams, and they fall over and hit the plaintiff, who's standing next to him. What happened? Did the plaintiff win that case? Anybody? Yes. The plaintiff won. 240. Why? Well, first of all, we have to go back to 1995, and many of you may remember a case called Miseriti versus Mark IV Construction. Anybody remember that? Okay. And that was introduced, as you know, the same level rule, right? And who wrote that opinion? My young friend? Judge Saparic wrote that opinion. And who wrote the opinion in Walensky? Judge Saparic. So what Walensky did was reject the same level rule that had been enunciated some 15 years before in Miseriti, which she wrote because of the changing body of law, because of running. Okay, and so they applied Runner, and they said this single decisive question is whether there's an elevation differential. Well, what's the elevation related differential here? Stand up. This is Chris Sally, my partner. He knows what I should really be speaking about the law. He knows more about it than I do. I go to him for advice, but he's a little taller than me. But Chris, imagine Chris is 10 feet tall. To me, he is. But and he falls over on me, and I'm only 5'6". That's an elevation-related differential. Because that's the second crime. The harm, the injury is caused by the harm which flowed directly from the application of the force of gravity on the pipes. They're hit by debris, they fall. Summary judgment for the plaintiff. Now, the last time we did this seminar, and we've been doing it for about 8 years or so, at least, but the last time we did it was in December of 2012. Can everybody hear me all right? Yeah, I have a big mouth. We last did this in December of 2012, and I said at that time, and it bears repeating because of the changes in the court. I said at the time that for me, what was happening at the court was that there was an obvious philosophical difference with regard to the interpretation of Section 240. And you know, when I use 240, I'm talking about 240 brands of wine, right? You had Judge Piggott, who started out, by the way, as a plaintiff's lawyer, very, very nice man and a very bright man. I had the pleasure of meeting him on several occasions. But you had Judge Piggott leading a faction consisting of himself and Judges Grafeo and Reed, which really interpreted Section 240 more restrictively than a faction led by Judge Littman, joined by Judge Saparic and Jones, who interpreted 240 much, much more liberally, and you had Judge Smith as a swing vote. And so you can see how it fell out, how it played out. And Walensky, Piggott, and his group dissented, and they got them back in a case called Salazar, which is in the materials. I just don't have time to go into it. Okay, so where are we now in March of 2014? Judge Jones sadly died much too young, and Judge Saparik has retired. We now have Judge Abdul Salam on the bench and Judge Rivera. Judge Smith will be 70 in August of this year. So at the end of the year, we're going to have another judge replacing him. We don't know who. It's anyone's guess. And in 2015, Judge Lippman is going to turn 70. So by the end of 2015, we're going to have at least 2 more new judges. But I said at that time it would be interesting to see what happened when another major 240 case came down. So, one did. And it's not in the materials because it came out on, it was decided on February 20th of this year after the deadline for the materials to be submitted. The case is Fabrizi versus 1095 Avenue of the Americas. And let me give you the site on it. It's 2014 NY Slip-Up 01206. And as far as the appellate division decision, it's in the outlines. I know it's in the Gair et al. Outline at pages 76, 80, 114, and 118, but that's the appellate division, but it contains the facts, and I know Brian has it in his outline for the facts. It's important for you to read that case. Has anyone read Fabrizi yet? Okay, one person. All right, good. So don't answer my question, because you know the answer. Okay. Plaintiff is an electrician, and this gets into the falling object area, but it's elevation, falling object. A plaintiff is an electrician working for an electrical company, overhauling the electrical system in a building. And the plaintiff's installing conduit piping. Conduit piping in these, it can be polyurethane, metal, these are metal conduit pipe, which electric wires go through, and they are hooked up to transformer boxes. Here they were referring to them as pool or pencil boxes, same thing. It's the transformer box where they have to join. And the plaintiff, in order to do his work, and this was not decided, this case, I want you to know, on recalcitrant work or assault proximate cause. The plaintiff was required to cut a portion of the conduit piping, and in order to do that, he had to remove this pencil box, pool box, or transformer box, as I like to call it. I guess the correct word is pencil box, although I've heard a lot of workers call it pool boxes. He has to take it off, and what happens is an 8 to 10 foot long conduit pipe hanging from another pipe dangling, okay? And it's connected to that other pipe by something that's called a compression coupling. A compression coupling is no more than this. It's like a metal sleeve that connects pipes together. So it's a piece of metal, and it's called compression coupling, and it clamps on, and that's what was holding it, securing it to the other pipe. It was securing it, I think. That's what it's for. Okay. Well, plaintiff's drilling on the floor, and the compression coupling, these metal sleeve, can't withstand the vibrations of the drilling, and the pipe loosens, the pipe that's being held to the other pipe by the coupling separates, falls, hits plaintiff in the hand. The Supreme Court, the Supreme Court granted plaintiff's summary judgment. The First Department modified, holding plaintiff failed to establish as a matter of law that defendant's failure to provide a proper safety device. Here, he alleged that it should have been what's called a set screw coupling. It's just a different type of a way to hold pipe together, conduit pipe together, okay? And it has to be held together. You don't have 80 feet long conduit pipes unless you're under the street, but so within buildings you have these pipes and they have to be coupled together, okay? So that was his allegation, but they said question of fact as to whether that was a safety device. Now, it goes up to the Court of Appeals. Now, we all know, don't we, that we had Narducci decided in 2001, right? 2001, and which said that in the falling object case, the object had to be in the process of being hoisted or secured, and we had a rash of decisions tossing plaintiff's cases, and then until 2005, when Altar was decided, which said it just didn't have to be in the process of being hoisted or secured. It had to at least be something that needed to be secured. And then you had Quacquaracci, I think, 3 years later, in 2008, which affirmed that. And so that's the law on that. It doesn't have to be in the process of being hoisted or secured. It needs something to it has to be something that has to be secured in order for 240 to apply in the falling object case. So we all understand now what happened. This pipe fell because the compression coupling failed, and the plaintiff is saying, hey, you should have had a set screw coupling. So did the Court of Appeals grant plaintiff's motion for summary judgment? Who thinks they granted it? Who thinks they didn't grant it? Who thinks they threw out the case? They threw out the case, okay? And that's why I said it was back in December of 2012. It would be interesting to see what happened. Now, by the way, Judge Salam did not take part in this decision. Judge Rivera did, and she joined Judge Lippman in dissent. And who wrote the majority opinion? Judge Piggott. And with Raffaele, Reed, and Smith concurring, right? So that faction said we are rejecting plaintiff's assertion that the compression coupling is even a safety device. It's not. And as far as the set screw coupling, which plaintiff alleges should have been used instead of the compression coupling, so what? It's not a safety device either. These are just things, devices that are used to attach pipes together. But to do what? To secure them? Well, the majority would argue no. They're to hold them together when they're in position, in a permanent position. Well, Judge Lippman says, that's a really myopic view to take, because in this case, it wasn't the plaintiff's fault that these pipe was hanging, because he had to remove the pull box, pencil box, transformer box, whatever you want to refer to it as, in order to do his work. So it's hanging there, it's dangling, it is being secured by this compression coupling that fails. Why isn't that a 240 case? You have an elevation-related differential, and you have a securing device that fails. Why indeed? Well, if you buy the majority opinion, is as I said, it's not as 240 enumerated device, but we all know that 240 says enumerated, gives all these different devices, and at the end, what does it say? And other devices. So I really don't get this decision. I mean, I get it. I don't objectively speaking, not as a plaintiff's lawyer, but based on past cases, I don't agree with it. Maybe some people do. But here's a case where you really have an elevation and you have a safety device, well, not according to the majority, but here's what Lippin says. The single decisive question should have been answered in the affirmative. Remember, was it an elevation-related risk? And the sleeve, it's because it's a metal sleeve, holding the pipes together was inadequate, and therefore summary judgment should have been granted. It was. Okay, now, I have a few minutes. This is a strange case. Okay. This is a First Department case that was decided in February 4th, and it's in the submissions. I don't know, it's in the Gair et al. Submission, page 104, and it's, so you'll have the site, and I think it's in Brian's as well, I can't remember, but listen to this case, all right? Plaintiff is working on a, and I'm just trying to give you a sampling of the cases. I'm talking about concepts because I don't want to, and you can read the cases. I don't want to bore you to death and get up here and read every case. You read them yourself, but the concepts are what are important. But think about concepts. Chris Sally always said, when a case comes into the office, and we work together on construction cases constantly, and he always says, the plaintiff has to tell a labor law 240 story. That's not, it means that we're going to give them the story, but we want to hear something that fits into the law, so you have to know the concept. Will this particular plaintiff's story be a 240 story? Will it work out? Will we be able to win summary judgment, or at least survive a motion to dismiss our case? We want really a case that we're going to win this summary judgment, but we take other ones that will go to trial and maybe a question of fact, because you usually get a directed verdict after all the proof gets in anyway. And even if you can't, these cases are very, very winnable. They're more defensible now for you defendants on the sole proximate cause defense, which has subsumed the recalcitrant worker defense, which I'll get to in a minute, hopefully. Okay, so this case, Pipa, First Department. So the plaintiff's working on a construction project to rehabilitate Yankee Pier, which is a pier in New York Harbor, and he's standing on what's called a float stage. It's really a work platform on the water, but they call it a float stage, okay? So, get this, here's what happens. I guess a big boat goes by, and a wave rocks the stage, because it's you know, on pontoons. It rocks the stage. So the plaintiff loses his balance, and he grabs a pipe hanger that's above to keep him from falling over the side of the stage into the water. I forget what time of year this happened. It might have been a good day for a swim, I don't know. But seriously, he grabs a pipe hanger above him to keep him from falling, and while he's doing so, his foot tripped in a hole, and he fell on top of the stage. That's what happened. So, he moves for summary judgment under 240. Okay, so we've talked about the concept, right? Elevation-related differential, force of gravity, which you don't really need here because it's a guy falling. So, all right, who thinks the plaintiff won? Who thinks the plaintiff lost? All right. plaintiff won summary judgment. Now, here's what the court said. The court held, although plaintiff's injuries resulted directly from his fall on stage at the same level where working, he fell while struggling to avoid the elevated related risk of falling into the water. Now, I assume he couldn't swim. Listen, I looked at this case and I said, I don't get it. But then I looked at it and I said, hey, wait a minute. Judge Tom joined in this decision for the plaintiff. I mean, Judge Tom is not exactly someone who reads the labor law very liberally. As we know, he's very restrictive in his opinions on the labor law. He joined in this decision. So here's what I think it turned on. And if you read the case, I think you'll agree with me. Plaintiff's got a really, really good expert affidavit. And this affidavit, according to the court decision, I haven't read the affidavit, but it must have been a good one. And we always try and get good affidavits in our summary judgment motions. They're very, very important. And certainly in a case like this, which is, you've got to say, at least borderline, right? The expert affidavit set forth numerous safety devices which would have prevented the accident. Now, this is the next case it's not in the outline, okay? But so I'm going to give you the name of it, and the name of the case is Penaranda, Penaranda v. 4933 Realty, LLC. It's a First Department case decided March 11th of 2014. Here's the site, 2014 NY slip-up 1547. Everybody got that? 1547. In this case, and it sort of goes to the covered workers area too. And by the way, if you want everything you need to know about covered workers is in Brian Schutz's outline, okay, or his submission or his book. It's a terrific discussion of it. But the court, this was a First Department case. The court held there to be, on the record presented to them, the court held there to be a question of fact as to the plaintiff's work was sufficiently related to the construction project, because what was going on is that the construction project was building a parking lot outside the defendant's warehouse. And at the time of the accident, the plaintiff was working in the warehouse, moving plywood, which it was alleged interfered with the construction project. But here's what happened. So the plaintiff's helping to remove this plywood, and he's put on a bobcat. A bobcat is a brand name for a skid steer loader. You all know what skid steer loaders are? Skid steer loader. Bobcat's one made by Clark Equipment. Skid steer loaders are these little machines that are like front-end loaders, with one exception. Instead of the lift arms being in the front, the lift arms are in the rear. So they come up like this, and you see them in cages, these little small things. I once had a products case with a skid steer loader where the lift arm came out, the gates, the side screens were taken out, and the guy hit the switch by mistake. He crushed him with that. But those are the skid steer loaders, okay? So it's a bobcat. So very important when you handle a construction case to learn what types of equipment are. And you can do that now much easier than when I was coming up, because you go on the internet and look at them all. I used to go to construction sites all over the city and peek through the things, or I'd get friends of mine who were construction workers, get me a hard hat, get on the site, and get to know these things. Okay, 10 minutes. Okay, I'll be so anyway, he's on the, so we know it's a question of fact whether it's covered work, but, so he's on the Bobcat. The reason he's on the Bobcat is he's going to be being used as a counterweight to back so the Bobcat won't flip because there's plywood's on the front forks. And what happened is the two front wheels lift up and he's thrown off. And the court held, assuming plaintiff was engaged in covered work, we find that falling from the Bobcat is a type of gravity-related event contemplated by the Court of Appeals, citing running. Okay? So, now, you know, at least in the First Department, that falling, remember those truck cases where they were all, where the Court of Appeals threw them out when someone fell off a truck, although that's limited to flatbed trucks, I think, because some of these trucks have ladders. But how far could the distance been? But you get back to these concepts. You have, what's the elevation-related risk? I guess getting thrown up in the air. And what's the gravity? The gravity is the force of the Bobcat when it flips that it exerts on the plaintiff to throw them up in the air and fall. Was this what 240 was intended to cover? It's up to the courts, isn't it? Not up, I mean, so that's what it is. Now, I have 10 minutes, but there's one case I just got, it's in the outline, but I just got to tell you real quickly about it. I don't tend to go over all of the ones I was going to, but I call this the membrane case. It's at 103 of the Gair Sally outline. And it's Jackson versus Heitman Funds, and it's a third department case, and you'll have it, the site is in here, the full site. It was decided in November of last year. But the plaintiff is working on a roof replacement job, and he's injured when a handle of what's called a roll carrier. A roll carrier is used to unload rolls of membrane on a roof, okay? And what happens is the court held that there was a significant elevation differential, but a question of fact as to whether a safety device could have prevented the accident. But listen to what happens. I'm going to read it to you. Here, for the purposes of defendant's motion, plaintiffs established that a membrane roll weighing between 600 and 800 pounds was hoisted by the roll carrier to a height of approximately 1 to 1.5 feet. I'm sorry, 1.5 feet off the surface at the time of our accident. And what happens is it falls, and it doesn't hit the plane, the membrane. It hits the machine, and the handle comes up. Okay? In our view, despite the relatively short distance that the membrane roll fell, it constituted a significant elevation differential given its substantial weight and the powerful force it generated when it fell so as to require safety devices set forth in Labor Law 241, citing what? Runner, woman, etc. 5 minutes, okay. Now, take a look also in the outline at two other interesting cases, Marrero at page 102 and Zarnak at 118. Now, let me give you another case that's not in the outline. And I bring it up for a reason. It's Guzman, Guzman, V 170 West End Avenue Associates. 2014 NY slip up 1537. I bring it up for only one reason. Plaintiff was struck by a 100-pound electrical cable that fell from a height of approximately 27 stories because it was improperly secured to a scaffold. Court held plaintiff not required to show the cable was being hoisted or secured when it fell. And I bring it up for a reason, because it shows you how much the law has changed. Remember Narducci? This case would have been dismissed after Narducci. If this case had been decided between 2001 and 2005, it would have been thrown out, as many cases were thrown out during that time. Then, I told you the pendulum. We had Guardaracci, I never pronounced it, but I'm close. And now, this is a 240 case. Okay, sole proximate cause, recalcitrant worker. Not that much has really changed in this area. I just want to say very quickly, if you look at the cases over the last 4 years, it's very, very apparent, and I think all of the defendants' attorneys and claims representatives here will agree with me on this, that the recalcitrant worker defense has been really subsumed by the sole proximate cause defense. In other words, defendants are moving for summary judgment on sole proximate cause, even in the recalcitrant worker scenario, and courts are analyzing these cases on that basis. Now, the latest still remains the case on recalcitrant worker and sole proximate cause, if you will, is Gallagher versus New York Post, which was Court of Appeals in 2010. The facts, if you don't know them, they're in both Brian's and my submissions. Gallagher, again, is one of these cases that's constantly cited over 90 times as of this week. And it remains the latest word regarding the recalcitrant worker defense and really the sole proximate cause as well. There's two types of defense, okay? There's a failure to use available safety devices, right? The recalcitrant worker defense. And as Brian Shute likes to say, every other stupid thing the plaintiff could have done, okay? Really talking about misuse. I would submit to you today that in order to win on a sole proximate cause defense, maybe not in the second department, but certainly everywhere else, you're almost going to have to show as a defendant the plaintiff misused the device because you're going to have to really show a superseding, intervening cause, which we all know. And the leading case on that is Cush versus the city of Buffalo back in the 70s, right? Just so we're clear, under Gallagher, we're now, by the way, Cahill is really not the law anymore. We're back to the to the 90s, to Hagen, Stout, Jastrovisky, and Zimmer, Smith versus Hooker Chemical. Okay, in order to win on, in order for defendant to win on sole proximate cause defense in the recalcitrant worker scenario, defendant has to show 1, safety devices readily available at the work site. 2, plaintiff knew he was expected to use them. And 3, for no good reason chose not to. That's what you have to show. It's no longer Cahill. You have to look at Gallagher, okay? Now, how much? 3 minutes?
About a minute or two.
Okay, minute 2. Blake versus neighborhood housing, as you know, decided in 2003. It's still good law. It's been cited 750 times. As I said, I submit that you have to show a misuse. And here's the most important language that you must look at in Blake. It's crucial. And I'm just going to read it because it's so important. Under labor law section 241, if it is conceptually impossible for a statutory violation, parens, which serves as the proximate cause for a plaintiff's injury, close parens, to occupy the same ground as a plaintiff's sole proximate cause for the injury, Thus, if a statutory violation is a proximate cause of an injury, the plaintiff cannot be solely to blame for it. Conversely, if the plaintiff is solely to blame for the injury, it necessarily means that there has been no statutory violation. That means all the plaintiff has to do is show that there was a statutory violation, a safety device wasn't provided. At the worst, there's going to be a question of fact. You as a defendant are going to have to show almost, as I said, a superseding, intervening cause of misuse of the device. We're really back to the expansive reading of the labor law way back in 1985 under Zimmer versus Tremont County Performing Arts Center, right? In 1985. And after Runner and Walensky, there's been an expansive reading of Section 240, where we have all of these cases that where these 1, 2, 3 feet elevation differentials, and plaintiffs are winning. Can I just give them a couple of quick sites and I'll sit down?
Absolutely.
Okay, thank you. Okay. I want to give you some cases that you should look at that aren't in the materials, if I may. I don't have time to give you the facts, but just so you know about them. Morado-Rodriguez, the Riva Construction Group, First Apartment, 2014 NY slip-up 1408, decided March 4th of 2014. It was a falling worker case, and there was a question of fact as to whether he was a recalcitrant worker. Another case, which is Chiaffi, C-I-O-F-F-I v. Target Corporation, decided by the Second Department, February 26, 2014, site 2014 NY slip-up 1290. It was a sole proximate cause case where the court held it was a question of fact to go to the jury. So it's very important, obviously, for defendants to look at it, because they did enough jobs so that at least they got to go to a jury on it. Now, by the way, the lower court opinion has a lot more of the facts, and that's at 2011 NY Miss Lexus 4708. Let me give you the slip-up, it's better. 2011 NY slip-up 32584 parens U, close parens. Okay? Now, I gave, I don't think I gave you the Panoranda site, but in case let me give it to you in case I talked to you about it. That's a Bobcat case. 2014 NY slip-up 1547, in case I didn't give it to you. Now, there's a permanent structure cases. We all know that in a permanent structure case, foreseeability is a requirement. A plaintiff must have shown that the collapse of the building, the stairway, whatever, was foreseeable. It's required. This is a big, some judges would like to have it in every case, but we know it's required. You cannot win a permanent structure case, even if a stairway is being used as access to the work site, unless you show foreseeability. Two recent permanent structure cases, I'm sitting down right after this, Chris. Gair versus Neighborhood Partnership Housing. It's a First Apartment case. 2014 NY slip-up 457, January 28th, 2014, First Apartment. And they held that it was foreseeable when the building collapsed. Another permanent structure case. I want you to understand this foreseeability requirement. That's why I'm giving you these cases. It's Garcia versus Neighborhood Partnership Housing Development. And it's First Department, January 21st. 2014 NY slip-up 298. Another case where an architect did a field report that showed the building was weak, it collapsed, and the plaintiff did get summary judgment in that case. One more falling object case for you. Actually, I have to give you two more falling object cases, then I'm going to sit down. Humphrey, decided January 28, 2014. It's a First Department case, and it's actually has I got a copy with the official, well, unofficial, it's 979 subsecond 317. Okay, thank you very much. I hope you got the concepts. These are the concepts that you have to work with. All the cases are in the outline, and thank you very much.